After years of criticism leveled at the Ontario Municipal Board, the province this week replaced it with a new tribunal that will consider municipal development proposals and land matters. The change has some people rejoicing and others concerned. Let's find out what's new and whether it fixes what people didn't like about the old OMB with Marcy Burchfield. She's Executive Director of the Neptis Foundation. Patrick Harrington is a partner with the law firm Aird & Burles LLP, and Martin Regg, Ontario politics columnist with the Toronto Star. And it's good to have, I'm going to say, you two back here, and you here for the first time, because a little more than a year ago, we did convene a discussion, which you two participated in, to look at what aspects of the Ontario Municipal Board process ought to be changed. We had a bunch of ideas kicked around, including some of these. Sheldon, go.
I think that it should be significantly better resourced than it is at the moment to allow folks who have an excellent career to give it up to become a board member with some certainty of continuity and support. I think the board is very disheartened and off balance at the moment.
The OMB currently has something called a citizen liaison office, and you may be shocked to find out that there is only one person at the citizen liaison office for the entire province.
We have to recognize the OMB is rough justice. It can't be perfect, and so it's better to have two panelists instead of one, because one person's more likely to mess things up.
It's time for bold reforms when it comes to the OMB.
Like what?
Bring back the authority to the local municipalities.
All right, let's review what in fact has happened. Patrick, is the new system that is in place the bold reform that was suggested in that last clip?
I wouldn't go as far as saying it's bold reform. I think it was a lot of tinkering with the tests by which you get to the OMB for a full appeal. We've recently had the rules for the new LPAT tribunal, and much of the processes...
LPAT standing for, we hate acronyms here, so you got to say them
It's the
out.
Local Planning Appeals Tribunal.
There we go.
And we are now to refer to it as the tribunal as opposed to the board. The tribunal has its own new set of rules, and for many of the hearings that the average citizen will be participating in, minor variances and things like that, nothing has changed. The same tests, the same processes, the same board members.
Same board members.
Same board members.
So the people who were on the OMB are now on the LPAT.
It's a bit of a misnomer to describe it as an abolition of the Ontario Municipal Board. The Ontario Municipal Board Act, which has been around since 1932, is no more. But the Ontario Municipal Board has actually been transformed into the Local Planning Appeals Tribunal, and it remains Ontario's oldest administrative tribunal. But all of the members, and it says this in the legislation, all of the members of the OMB remain members of LPAT. So there are certain procedural changes, but you are still standing in front of the same members at the same location in Toronto for more or less the same purposes.
Let's find out how many members, because you said in your recommendation there shouldn't have just one person hearing things, too much power in one place, should have at least two. Is that the case?
Well, I think whether it's one or it's two or the same number of members of the board, the important point is that they are not the same people with the same powers. They have been completely, the board has been reincarnated. So if it's being reborn, at least it doesn't have the same outdated and archaic powers that it had for 100 years ago. Remember, it was created, it's the oldest tribunal or board it was, and it was created in the era of railways and railway barons and robber barons, and that was their job. So this is in many ways a huge change, even if it's the same gang at the top, because they can no longer just take over the planning process as they used to. And I imagine you want to talk about that later, but it is a completely different ballgame. And thankfully, we have gotten rid of the name, even if it is the same antecedents, the same old structure, because the Ontario Municipal Board was just a turnoff, right? It was this remote body, and LPAT is not exactly going to become as well known as KFC. But the local, I have to write this down, the Local Planning Appeals Tribunal, at least it's local and not some remote organization.
Well, let's see how local it is, because, Marcy, in that clip there, you heard Tom Marakis, the city councillor from Aurora, say that he wanted greater authority given back to local municipalities. Is that happening now?
Yes, I would say so. The transition from OMB to LPAT has brought along this change that Tom and other councillors have publicly asked for a very long time, and that is bringing the powers back to the municipality to make the local decisions on local land use planning matters. But I would say at the same time, two caveats, that they still need to have responsibility for making their local official plans and their decisions that are coming out of council align with provincial policy. And we can get into what that means.
Who's the they here that you're talking
They
about?
being the municipalities. Municipalities, municipal councils have to conform, their plans and their decisions have to conform to provincial plans and provincial policy.
And if they don't?
And if they don't, so one, they have to be responsible for that particular aspect, and then two, they have to be accountable. And if they're not accountable for that decision, then it does. There is the opportunity for these appeals to go back to LPAT.
We also heard, Patrick, the suggestion that the Citizen Liaison Office needed to be expanded. Is that happening?
Yes, there is now a service center associated with the LPAT. It's in its infant stages, and they're still in the process of deciding what is the delivery system for this. But the vision behind it is akin to a legal aid office with specialty in the practice of land use development, planning, and law.
I'm hearing they've got a budget of $1.5 million, and they're going to help local people who are not experts in this field navigate their way through it all. Is that true?
That is the idea. I practice in front of the Landlord and Tenant Board and sometimes the Human Rights Tribunal, and oftentimes unrepresented appellants come before them without necessarily knowing what their rights and obligations are going to be. And the idea is to provide them with assistance and perhaps even help them throughout their cases. The idea is to put that into the LPAT stream to help those objectors understand, what does the zoning bylaw already provide for? What exactly are they asking for? How do I get through this new process? And the fact that the province is putting the resources behind that is a good thing. How the delivery system will work is yet to be determined. We're living in the information age, and a lot of this can be accessed through websites and through online delivery. So whether or not you're going to have somebody sitting in an office waiting for someone to come through, or whether or not you're going to have a call-in helpline, or whether you're going to have a website, the province still has to make that decision.
Steve, can I just jump in on that, if I may? That's a really important point, and I'm glad you raised that. That's going to be a real test for the LPAT. Can I just call it KFC for the rest of the show? Because legal aid is such a cornerstone of our judicial system, but it is so fraught. It is such a great idea, but in practice, how does it work out? There's never enough money. So that's going to be one to watch. But it answers one of the biggest concerns about the old OMB, in that it was kind of asymmetrical warfare. You had well-financed developers who could afford top experts like Patrick or Jane Pepino, who understood every aspect of the nuances of the legislation and how the OMB operated in this kind of black box, unpredictable way. And so at least they have tried to level the playing field and given people access to a little more help so that they're not completely outspent and outmuscled.
These changes were shepherded through by the Attorney General of Ontario, Yasser Naqvi from Ottawa, and he had this to say about the new system. I want to read this quote of his, and then we'll get everybody to comment. The Local Planning Appeal Tribunal, LPAT, will stick to the role of a straightforward appeals tribunal. It will simply review the decision City Council made, said Naqvi, and won't be able to make planning decisions of its own. The test is whether or not you were consistent with your local planning documents. Now, does that make, Marcy, help us out with this, does that make challenges over specific developments by community groups easier or harder? Or do we know?
So I'm not sure that we know. I think one thing to keep in mind here is that because the balance of power is now shifted to the municipal councils, I think the outcome is that we don't really want to get to that point where it's an appeal, a site-specific appeal, right? Partly what the municipal councils are responsible for is to have official plans that conform to provincial policy. In Ontario, that means the provincial policy statement, but in the Greater Golden Horseshoe, where the vast majority of those OMB hearings were, it took place, the appeals were in the Greater Golden Horseshoe, this large geography that surrounds the city of Toronto. And there is a process now by which that provincial policy is being transformed and being incorporated into the local official plans. And that process is the municipal comprehensive review. And there's a lot of work that municipalities are doing to get to the stage of a final official plan. And so I think the idea here is to get the public engagement happening before an appeals process happens, and that's really what this is about.
But here's what I need a better understanding of this, Martin. In the past, if a neighborhood group didn't like a particular decision made by City Council because Council is going to allow the erection of a 50-story building and the neighbors think that that's way too much, They could try to marshal their resources together, go to the Ontario Municipal Board and fight it, and as you point out, get rough justice along the way. Under the new system, if that 50-story building is consistent with what the municipality wants and with what the official plan provides for, game over?
Essentially, yes. And that's not as bad as it sounds or as good as it sounds, because in the first instance, it forces City Council now to grapple with the guts of the case in a more realistic and grown-up way. In the old days, City Council could just pass the buck to the OMB and rally to the side of NIMBY or local councillor, or local ratepayers, or else risk losing in the next election, as has happened, and just know that the OMB, nudge, nudge, wink, wink, would eventually set things straight. So there's now going to be a new discipline for local councillors to not just play politics, but also understand that they have to make a wise decision. They have to be faithful to that plan, and they can't just indulge NIMBYism. Look, I always had a problem with the OMB, but I'm not a NIMBYist. I actually don't like NIMBYism. I do believe in the greater good, expropriation where necessary, for the public interest. So in many ways, I think that this new process will create a more coherent system.
Can you see, or are you seeing yet, politicians being more responsible for their own decisions as opposed to saying, love to help you neighborhood groups, but look, it's out of my hands and it's at the OMB now?
I think that was definitely the attitude that pervaded when the Ontario Municipal Board had the power to make the final decision. But what we have now is a system whereby an appeal will go up to the new tribunal. They will decide whether or not the decision exhibits an issue of conformity with the local official plan or with provincial policy. If it does, the decision then gets sent back down to the municipality with a 90-day window in which to either change or make an adjustment to their decision or leave it alone, in which point it goes back up to the LPAT, and at that point the LPAT has the power to make the final decision and would carry on with their trial. Now, our discussion earlier about citizen involvement, you can imagine how confusing that is for somebody to go back up to the tribunal, back to the municipality, back up to the tribunal for a full hearing. So it's more of a careful what you wish for. But the idea being that you're allowing the municipality to take not one but two cracks at getting it right in accordance with provincial policy, and that's what I think the province wanted to see.
Having said that, I mean, some of these hearings used to go on for a while, right? And some of these disputes would take quite a long time to resolve. Even with the process as you just described it, should things happen faster in the future?
There's actually now regulations in place that require the LPAT to render decisions faster. Some of the bigger applications like official plan amendments and zoning bylaw amendments now have a timeline of about 10 to 12 months in which the tribunal is to take the appeal and render the decision. And then some of the smaller appeals, like minor variances, must be rendered within 6 months. And that appeals process, I talked about that first step up to the tribunal, there's no ability to call or examine witnesses, which is where a lot of people who were unrepresented were running into trouble. They didn't have the money to pay for experts or lawyers or things like that. Now what you're going to get is a maximum 75-minute submission to convince the tribunal member that there is an issue to get it sent back. And if you fail, it's done and the municipal decision stands.
Can I just try to put that in a different context by analogy? I've often thought of the OMB, which I love to beat up, but I'm not going to relitigate it here. But I always compared it to the Senate, just as old. And until recently, you had lifetime appointments to the OMB, just like the Senate. And the difference, though, was that the OMB was in some ways more powerful because it could actually take over the case and relitigate it itself. It wasn't an appeals tribunal like the Supreme Court or like the Senate.
No, they could decide.
They could actually start the whole thing over again and call witnesses and so on. So you say people will only have 75 minutes, Patrick. Maybe that's not a bad thing. And you just argue on the narrow points of the law, or was it faithful to the official plan, instead of empowering the OMB to just start all over again, bring in the planners, which was much more expensive for ratepayers, and have a whole new fight, and which almost meant that the initial hearing at City Council was almost a pretend or a phony war. The real fight took place next at the OMB, so you had to have not one but two full-fledged contests. Now, at least it's more of an appeal. If you don't like it, just like the Senate, you send it back to the House of Commons, and you let the elected officials decide, and then it goes back.
Let's do some more comparing and contrasting, okay, from the way it was to the way it is now. During the consultation process that the Attorney General held on the old Ontario Municipal Board, submissions were made to include language addressing density, design, and affordability. Are any of those three things included in the new framework? Do we know?
So I think Patrick would be a better person to ask that question, but I think that it goes back to that language is in the provincial policy. That language is in the official plans. That language is in, the secondary plans that talk about more specific areas and more specific designs for specific areas. And the idea is that the public engagement process will happen during that period of time, and that's where the right place for design, density, and other amenities, public amenities, public benefits. You have a place like Hamilton.
Martin's in my hometown.
That right now what they're doing is they're doing the review of their official plan, they're doing their secondary downtown plan that's 10 years old. At the same time, they're redoing their zoning bylaws and making tall building guidelines so that there's a maximum height of which to plan. All of that is to bring some certainty into the process as to what residents can expect in that area. Pre-zoning is another tool that municipalities can use, so that pre-zoning just essentially means you will know what the maximum height of a building in a particular corridor is, and the idea and the justification of why that density and that height is in place.
So if you can only get 25, don't come forward with a 50-story proposal.
Unless municipalities have set aside a process by which they say, okay, we'll give you some more density, but for particular public benefits that they've already worked out with the community as to what that would be.
Give us some daycare, build us a park, all that kind of stuff. Do you want to add on to that?
Certainly, Marcy's correct in that a lot of the impetus towards density and affordable housing is provided through the provincial plans that we already have. Of course, the difficulty is those are provincial plans. It's difficult to funnel that down into an individual municipality, and municipalities are very different. Toronto and Hamilton, very different from what you'd see outside of the GTA, outside of the Golden Horseshoe. Different plans, different objectives. But I think what has been added to the municipal tool belt are things like the ability to protect around infrastructure, around high density, to allow high density to be built around areas where you're going to invest in rapid transit infrastructure. For example, in Hamilton, they're creating higher density around some of the areas where they're going to be bringing rapid transit to the city. And their ability to protect for that, to assign higher density, higher heights to those areas. And then once the province approves them through something called a major transit station area, those are now protected. You now have to ask council for even permission to try to amend them. But of course, the flip side of that is residents who may be living around it, who may not necessarily like high density, they don't get a chance to appeal it either.
I want to bring up an example of something happening actually just a couple of hundred meters south of where we're all sitting right now. This made your newspaper the other day, in fact, I think. Toronto City Councillor Josh Matlow, who represents this area, regarding a condo development project just down the street, had this to say. The Yonge and Eglinton area, including Davisville, which is just south of us, has seen unprecedented growth for several years, and it's critically important that along with social services, basic infrastructure can keep up with the pace of new residents moving into the area. This isn't a narrow debate about whether there should be development or not. It's about when there is development, it should support a good quality of life in our neighborhood. Josh is talking about a situation where somebody wants to put up a rather largish building, and the city so far is saying, no, you can't put it up because we haven't got the infrastructure to support all the hundreds of people that may be moving in there. Does this new process, to the best that you're able to tell so far, Martin, adequately address the problems of new development outstripping infrastructure to support it?
So there's no perfect answer because it's a bit of a yin and a yang. There's this, people who like to support the OMB like to throw out this, what I think is a bit of a red herring, that the OMB is actually protecting the laudable goal of increased density. All of us understand that density is necessary if you want to curb sprawl. But you can have too much of a good thing. And the problem with Yonge and Eglinton, or Yonge and Davisville, or Yonge and St. Clair, which are all nodes that have been identified for increased intensification.
Subway stations at each spot.
Perfect. But at what speed? And the problem with the old OMB, if I can beat them up again, is that
which you said you weren't going to do. But
which
here you go again.
No, but because you opened the door, Councillor. The problem with Yonge and Eglinton is that they would look at these high-rise developments, which perhaps on their face in isolation would be a good idea, but they didn't take account of the neighboring projects. So you could have endless numbers of new buildings at Yonge and Egg, And the OMB would say, yep, that makes sense, more density. But nobody was looking at the big picture except hopefully the people at downtown Toronto at City Hall and the planning department who were saying, whoa, this is overwhelming us. And I brought along, not meant intended as a prop, Marcy, but there is, it's not just that people are concerned about too much overrunning school services and overcrowding. They're talking now about sewers. Who wants a sewage backup in town? So maybe that's a bit of a scare tactic. But clearly, you can have too much of a good thing, and I think that was the problem with the OMB.
Is this a concern of yours in as much as this intersection has not only the Yonge Street subway line, but of course a new $6 billion LRT, which theoretically will be done sometime in the next few years, going east-west across this Yonge and Eglinton intersection as well. You have massive 60, 70-story condo units going up all over the place here, and then bungalows 100 feet away, on the side streets away.
Right.
This area wasn't really thought, I mean, you have to assume that this area was not thought of for the kind of density that's going in here right now. Is that fair to say?
Well, as Martin pointed out, the Yonge and Eglinton, North York, those nodes have been on the planning books for quite some time. But it's this dichotomy between high towers and really low-rise single-family houses that we have to move away from, and we have to find something in that missing middle, as they say. Either on and I think this is the point also, is that maybe there is a sewage capacity issue in Yonge and Eglinton. I couldn't answer that question, but there are also there are places where there's more capacity than there is demand in the city as well. And so part of the city's strategy could be looking at those other places and looking at how you transition to sort of some gentle density around these major transit station areas. So Patrick brought up the provincial policy that suggests in the growth plan that all the major transit station areas, which is every subway station here, every LRT station here, there's a radius by which those areas are defined, and some of that area will encroach into what's called stable neighborhoods. The yellow belt, as some people call it, because it's an area with lots of single-family houses that the zoning will not allow anything that's a little bit higher density in there. And the provincial policies and the implementation of those provincial policies at the local level will allow for some of those areas to be penetrated, I think, if you have a public engagement process by which people know what they're going to get. And it's not just the dichotomy of high towers and low single-family houses.
But if I read you right, the Toronto Star is going to have a great time covering all of these angry residents who are seeing more development encroaching on their peaceful little neighborhoods. Is that right?
So isn't it time that we have a process that's less reactive and more proactive? And that's, I think, where we're trying, where the planning process is trying to get to. It's moving away from that reactive OMB, sign on a front lawn that says you're going to have a 50-story building, on this property, and moving to something that people know what they can expect in terms of development, and are engaged early in the process.
Gotcha. With just a few minutes to go here, I think at the end of the day we need to figure out whether the new LPAT system is now better than the old OMB system. What do you say?
I have my concerns because the OMB system, and I'll come to their defense for a minute, was always based on evidence. It was the best evidence that won the day in front of the board. So I would come with my traffic expert, my engineer. If there's a capacity problem, my engineer would have to figure it out. And if the capacity problem existed, my client would have to come up with a solution and, in fact, pay for that solution. So it was always the best evidence that was intended to win at the OMB. When you're changing that process to now put that power into the hands of councillors and other ratepayers who may have influence over councillors, they're not exposed to the same level of evidence that an OMB member would be through a hearing. As much as we try to funnel that public discussion into a council meeting's agenda's got a lot of other things to cover. They can't sit there and listen to my engineer tell you about the sewage capacity or the traffic engineer tell you about what changes need to be made to the traffic signal. So, most of us have 5 minutes to get that case across to a councillor. And so what the councillor is going to have to rely on more and more is staff opinions. So staff are going to need the leeway and the resources to go out and engage the applicant's experts and to come up with these solutions either on a site-by-site basis or on a greater basis.
I got 30 seconds left for Martin.
Long overdue and early days, we can't say for sure, but at least we're not going to have these phony wars at City Council, which were just for show. And rather than holding back the good stuff and the compromises for the OMB, bring it on and do it to City Council and find a way.
He actually saved 10 seconds for you.
Great,
Fire away.
Thank you. So I think we're forgetting the role of the province here. There is a role for the province to play to make sure official plans and the planning documents actually do align with the provincial policies and the provincial plans. And that is a role that they have not played a very proactive part in the
province.
past. The province, yes. And so
You want them
this
to now.
absolutely, they absolutely have to play, because it will get bogged down in this punting war that goes back and forth between the LPAT and the council.
I want to thank the three of you for coming in and having this discussion about an incredibly nerdy subject. OMB versus LPAT. There we go. Patrick Harrington from Airdon Burles, Marcy Burchfield from the Neptis Foundation, Martin Regg from the Toronto Star. Thanks, everybody, very much.
Thank you.
Thanks.